Hello, I'm Robert Slater. I'm Department Head for Educational Foundations and Leadership at the University of Louisiana at Lafayette. I'm here with Dr. Richard Fossey, the Paul Burden Professor of Education Policy here, who's going to speak today about bankruptcy issues regarding and related to student debt. Richard received his doctoral degree from Harvard University and his law degree from the University of Texas at Austin. And he's got a blog on student debt. He'll give you the, what's the blog address on that?
It's condemnedtodebt.org.
Right, condemnedtodebt.org. And he's got a couple of books on student debt. But in this video, he's going to talk a bit about the bankruptcy laws related to student debt. Richard?
Okay. Most people say that it is impossible to discharge a student loan in bankruptcy. It's so impossible that you shouldn't even try. In fact, there was a very interesting article written by Jason Iliano. Looked at bankruptcy filings in 2007, I believe, and he found that there were almost 250,000 people who had student loan debt who filed for bankruptcy that year, and only about 300 of them even tried to discharge their loans because they were convinced they couldn't do it. Now, it is difficult. Congress amended the bankruptcy code so that a person cannot discharge student loan debt unless the debtor can show that it would be an undue hardship not to discharge the loan. Congress didn't define undue hardship, but the federal courts have, and they defined it on the whole very harshly. They used the Bruner test for the most part, and that test asks whether a person can pay off his or her student loans and maintain a minimum standard of living, number one. Two, are there additional circumstances that might make it impossible to pay off the loan in the future? And three, did the debtor make good faith efforts to pay off the loans? And there are many decisions which have been very harsh towards student loan debtors who came into court with very distressing circumstances. But there's been some changes, and people should know about this, and people who defend student loan debtors in bankruptcy courts should know about these cases. The two most important ones are a case called Roth versus Educational Credit Management Corporation out of the Ninth Circuit. The Ninth Circuit Bankruptcy Appellate Panel decided this case. Very important case. In this case, Janet Roth borrowed money to attend college at two institutions in Arizona. She never got the degrees that she sought, and she didn't make any voluntary payments on her loans. Over time, the amount of that indebtedness grew because interest was accruing. She probably had some penalties for default. So when she wound up in bankruptcy court, the amount she owed was almost triple what she borrowed. But when she filed for bankruptcy, she was in her 60s. She was living entirely on Social Security income of about $780 a month, if you can imagine that. She had chronic health problems, including diabetes, and she filed for bankruptcy. The creditor argued that she should be put on a long-term income-based repayment plan. And the creditor pointed out that she's so broke, she's so destitute, that she wouldn't even have to make any payments under that plan. But she argued for a discharge. It went all the way up to the Ninth Circuit Bankruptcy Appellate Panel, and the Ninth Circuit BAP Bankruptcy Appellate Panel discharged Janet Roth's debt. And the court said it's true she didn't make any voluntary payments, but she didn't fail the good faith test because the court said she lived frugally over the years. She did her best to maximize her income, and she never really made enough money to make significant payments on her loans. The court also said something else. The court said that it's a principle of equity that the law does not require a party to engage in a futile act. And the court said it would be futile to put her, at her age, in a long-term income-based repayment plan. That's a very good decision. And there's a concurring opinion by Judge Jim Pappas, who's a bankruptcy judge out of Idaho, and he said that the Brunner test is outmoded, and he said it doesn't really make any sense to impose these harsh terms on student loan debtors, given the environment that we're now in, with 43 million debtors, $1.3 trillion in student loan debt, people borrowing more and more money every year. And he said we need to create a new test that basically just asks whether people can pay it back. So that is a good decision. It's been cited, been commented on a bit. It's out of the Ninth Circuit. There's another important decision, the Krieger case out of the Sixth Circuit. That case involved a woman in her 50s who was living with her mother. Her mother was elderly. This woman had been unemployed for quite some time, filled out job applications for years, and never got a decent job. And the court pointed out that she'd never made more than $12,000 in her life. And she, too, had not made any voluntary payments on her plan. But the court discharged her loan, that said basically she had done the best she could under the circumstances. The court wasn't going to require her to leave the area where she lived to obtain another job, and it discharged her loans. There are a string of cases around the country that have ruled more compassionately for student loan debtors. And if you're contemplating bankruptcy and you want to see those cases, I've got a list here compiled by a friend of mine who's an attorney out in California. There's some good decisions in which bankruptcy courts have ruled compassionately for student loan debtors. It's a difficult thing to do, but I think people with the right fact situations, the right background, and particularly people who've made efforts to pay off their loans but have been unsuccessful, should really consider bankruptcy.
Great, Richard. Thank you very much for that summary of the bankruptcy cases related to the student debt. We'll have more videos on this and related topics in the student debt crisis, and we'll hear more from Richard. Thank you very much. Thank you. We'll be doing another video shortly.
Yeah, thank you.